Good day, Crime Talk aficionados. We have a big show for you today. First, it turns out Bryan Kohberger did, in fact, buy a K-bar 8 months before the quadruple murder he is alleged to have committed. And then, guess what? Karen Reed's request to continue her trial is denied. And this case has turned into the O.J. Simpson trial of our time. A complete mess. A woman is accused of killing her dog so that she can make her flight. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications so you know when we put up new content or we go live. Let's do this before we get to the show today. Go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll have access to literally thousands of databases across the country. They're all searched at one time. Could you imagine having to go to each database that was available to the public and doing a search? It would take you weeks, if not months or years. Guess what? CrimeTalkSearch.com searches all those databases literally while you wait, and a report is generated, and it's going to have all kinds of information about the person that you're searching. It's going to have emails, phone numbers, social media presence. Do they have a criminal history? Do they have liens, judgments? Are they married? Are they really divorced? Things you want to know about people coming into your life. So go to crimetalksearch.com, sign up for that background subscription service today. And remember, you can cancel at any time. So whether you want to do one search or you want to do 100 searches a day, you can do it while you have that subscription. All right, let's go ahead and get to the record for Thursday, March 20th, 2025. So there was a big dump yesterday as it relates to the Bryan Kohberger matter. A bunch of motions were released. Now, I have told you that all of this should have been released. And frankly, everything that's been filed, there's nothing that is so secretive or so prejudicial to anybody that it shouldn't have been a matter of public record and knowledge when these matters were filed. All right? So we'll leave it at that. At least the judge that we're in front of now has said that, hey, the public has a right to know, and we appreciate that. Now, obviously, we will give Bryan Kohberger the presumption of innocence, which he is entitled to, unless and until he is convicted or he pleads guilty. At that point, then the presumption of innocence will go away. Now, as you may also recall, the last time there was a big dump, there was all this information about Amazon searches and search warrants. And what did Scott say? I said, hey, the reason why these motions are being filed is because there's something bad in there. Now, we didn't know for sure, but I said it's speculation, but it's kind of an educated guess here that there's going to be something. And my guess is that he being Bryan Kohberger, purchased a K-bar in those Amazon searches that the defense doesn't think should come in. All right. When you file your case, the prosecution goes forward, right? The prosecution files the case, it goes forward. We get to motions hearings. The judge has to determine legal issues in the case. The jury decides questions of fact. The question of fact is, did Bryan Kohberger kill those 4 students? That's the question. Was it him? Not someone that looked like him, not someone using his identity, but it was in fact Bryan Kohberger, and he killed those 4 individuals unlawfully, meaning without legal permission or justification, that he did it knowingly and after deliberation, caused the death of those other people, as well as the burglary charge. But the judge decides questions of law. Judge, was the DNA evidence obtained illegally? The court says no. All right, so now they know it's coming in. Then we kind of get past those issues like that, the big ones, right? Motions to suppress statements and things like that, which really aren't applicable here because Bryan Kohberger hasn't made any statements. But now we get into the motions in limine. And motions in limine are really each side saying, Judge, don't let this in because it's prejudicial to my side. And that's what the judge has to determine. And obviously, allegation is that it's alleged that Bryan Kohberger allegedly used a K-bar to attack those 4 individuals and kill them back in November of 2022. They find a sheath, the sheath right here, right, with a little DNA on it right here in the button, whether it's this side of the button or not. Now, I was watching another channel. I thought it was interesting that they went out and bought a K-bar, and their sheath looks so brand new. This one was summer of 1988. Graduated from boot camp, right? Everyone had to have a K-bar. You put it on your web gear when you go to the field, all that good stuff. But anyway, I digress. They don't want it to come in that he bought a K-bar. That's bad, right? Because that's the allegation, that he used a K-bar to kill these people. Don't want that evidence to come in. Well, Judge, it doesn't prove anything. And so what they're arguing about is going to be, we're going to go through a quick summary. Then we're going to go through all these motions. And when I say all these motions, this is what was unloaded last night, ladies and gentlemen. But don't worry, I've been through it. I've narrowed it down to the key issues so that you don't have to go do it yourself unless you choose to do so. We're going to give you straight from the motions. We like the law, applying the facts to the law. And we go from there. So, all right. As mentioned, Bryan Kohberger allegedly bought a K-bar knife with a sheath and a sharpener on Amazon some 8 months before a similar knife sheath was found at the scene of the quadruple murder. Coincidence? I don't know. The murder weapon hasn't been found, but investigators found a knife sheath next to one of the victims. Now, police say DNA on the knife sheath matches Mr. Bryan Kohberger. And leading up to the trial this year, prosecutors and the defense are filing a flurry of motions arguing about what evidence should be admitted or not. And a motion filed this week refers to the activity of Bryan Kohberger's Amazon account. Prosecutors reference a search warrant police obtained to seize Mr. Kohberger's customer click activity pertaining to a knife and accessories from Amazon. And later in the motion, prosecutors write that the search was limited to March 20th, 2022 to March 30th, 2022, and say that was the time it was known Bryan Kohberger purchased a K-bar knife with a sheath and the sharpener from Amazon, probably because they talked to his family members. The defense has argued that the basis for the click history search was too broad and not relevant. A judge will hear that motion in April. Now, we also have defense attorneys have released never before seen data from the cell phones of the surviving roommates at the time of the University of Idaho murders. Now, obviously, Kohberger's on trial for the deaths of Zainer Chernobyl, Madison Mogen, Kaylee Gonzalez, and Ethan Chapin back in November 13th of 2022. Now, it has been revealed that around 4 a.m. that morning, one of the victim's roommates, Dylan Mortensen, came face to face with a masked intruder. And as he left the house there at 1122 King Road in Moscow, Idaho, panicked text messages between Mortensen and the only other survivor, Bethany Funk, show a light of the students' fears about what happened inside the home. So the cell phone records released last week show that the two students made a string of desperate calls and texts to their roommates, but got no response. Mortensen ended up leaving her bedroom on the second floor and going down to Funk's room on the first floor. And about 8 hours later, just before midday, a 911 call was placed from Funk's phone. Police arrived at the scene to find blood path with Mogen, Gonzalez, Chernobyl, and Chapin all stabbed to death. Now, in these new court filings released Wednesday, it shows that the accused killer's defense has unveiled a more detailed record of the survivor's cell phone activity in the meantime between the moments between Mortensen saw the masked man in the home and the moment that the 911 call was placed. The record suggests that the survivors were on social media at some point during that time frame, and in the aftermath of the intruder sighting, Funk made the first phone call to Mortensen at about 4:19 a.m. For the next 18 minutes, the records show constant activity on both of their phones as they call and text each other. At 4:34, Funk's cell phone accessed Snapchat, followed by Instagram at 4:37. Now, in the court documents, the next cell phone activity is at 7:30 a.m. when Funk calls her dad. She makes several more calls and texts, including to her dad and mom. Between 8:41 and 8:42, Funk took photos, and according to the defense document, Mortensen's cell phone was on Instagram between 8:05 and 10 a.m. Between 8:05 and 11:57 a.m., Mortensen's cell phone accessed Instagram, Indeed, and TikTok, according to the motion. Now, according to the filings, her cell phone accessed Instagram a final time at 11:54 to 11:57. The 911 call was made from Funk's phone at 11:56. The defense does not reveal what the surviving roommates were doing on any of the platforms or sites, and it's also unclear if they are using them to try to contact their roommates and friends. Now, the contents of the messages and phone calls has not yet been revealed. And it's unclear from the records whether the cell phone user was actively using the platforms or if the platforms were simply open on the phone. Now, in the document, the defense points to the lapse in time between the panic text and the 911 call and urges that the two survivors could have fled the home, but they didn't. Well, it was also kind of suggested that they didn't really know what was going on, didn't appreciate what may have happened in there. And college kid accessing social media at any given time during the day sounds about normal to me. Anyway, DM first claims confusion. Then after communications with BF, she claims fear of leaving her home. Now, despite her fear leaving the room, she joins BF downstairs. And to get BF's bedroom, DM passed the resident's front door, and BF was steps from the front door. Now, neither of them left the house. Neither of them called friends, family, or law enforcement for the help the defense writes in their motion. She was messaging on Snapchat. She was on Instagram, and she texted her dad. This is not an exhaustive list of activity on her phone. She was with BF, who also communicates with her parents and then later her friends. So in this filing, the defense accuses the state of having selected text messages and excited utterances and present sense impressions rather than giving the full picture of the call of the phone activity during the critical time frame. However, the defense also makes it clear that this is still only a more complete but not exhaustive view of DM and BF's communications and interactions with social media. The defense is asking the judge to block the text messages as evidence at trial and urges the court to look at everything that occurred during the timeline. The defense filing comes days after the 911 call was released for the first time, capturing the panicked voices of Mortensen, Funk, and two of their friends who had come to the house, where they say, something is happening, something happened at our house, we don't know what, as the call begins. The students are heard passing the phone between them as they tell the dispatcher one of their friends is passed out or not waking up. And they saw some man in the house last night, one of the callers says. The surviving roommates are expected to be key witnesses, obviously, in the trial. And whether the court allows in those text messages or not, it's all coming in because the witnesses are going to be able to testify as to what they did and to what they said. And they're going to be able to testify as to what somebody else told them, not for the truth of the matter asserted, but the impact it had on the listener. And then they're going to say what they did next. Like I said, Kohberger's defense is asking the judge to block any evidence referencing bushy eyebrows as well, and to block Mortensen from using those words to identify Kohberger when she testifies at trial. Now, although she has not identified Mr. Kohberger, testimony by DM from the witness stand describing bushy eyebrows while Mr. Kohberger sits as the accused at trial will be damning, as her pointing to him and says, he is the man. That's the man that did it. I don't know if the judge will allow that, but if he does, guess what? It doesn't really matter because it will all be subject to cross-examination, and the defense gets to test the veracity of that opinion that was in fact Bryan Kohberger. And the defense says, hey, there are some inconsistencies in Mortensen's description of the masked intruder, and the legal team also points to artwork seen on the students' bedroom walls, many of which have drawn people with prominent eyebrows. Cross-examination, ladies and gentlemen, it is coming in. And then we also got the photo as it relates to Bryan Kohberger, apparently taking a photo of himself in his bathroom, taken just mere hours after the alleged quadruple murder took place. And what does it show? Maybe what one could describe as some unique eyebrows, perhaps? Yeah, so we'll have to wait and see if that comes in, but I think it will because it was found on his phone. Anyway, in that picture, he's wearing a dress shirt buttoned up to the collar and some wireless earbuds in his ear. And the police are hoping that Mr. Kohberger's eyebrows in the photo lead to a conviction. So let's just quickly go through these because there's a plethora of information. Frankly, this is the most interesting trial I think that is going on right now. Very good lawyering. The lawyers are doing what they're supposed to be doing. And this is all on the way to making sure Mr. Kohberger gets due process and whether he is found guilty or not guilty. Obviously, the burden is on the prosecution to do that. All right, first one, defense second supplemental response to discovery. I'll save all the intro stuff, but basically they're saying that they're going to respond in a timely manner. Motion permission to exceed the page limit. And in this one, they are simply asking to leave the or exceed the page limit for the state's response to defendant's motion to strike the death penalty regarding the autism spectrum. disorder, which is kind of interesting. We'll get to that in a second. Stipulated motion to seal exhibits to defendant's second supplemental discovery response. And, this is all just kind of administrative stuff, but you got to go through it. All right. Next, a motion to seal exhibits to state's amended supplemental response to request for discovery regarding expert testimony. What they're requesting here is that the state is requesting that the court seal from public disclosure the exhibits attached to the state's amended supplemental response for discovery regarding expert testimony. Then we have a motion to file under defendant's objections under seal. Bryan Kohberger moves for an order to seal the defendant's objections to the state's motion in limine regarding the 911 call and objection to the state's notice. Well, that was denied because we got some of that. Motion to file defendant's exhibits in support of their objection to the state's motion for under seal. Defendant's motion for leave to allow witness testimony at the April 9 hearing. Now, it's interesting. We got the order on this the other day where the judge says, yeah, no, I don't need expert testimony. You've submitted, the defense has submitted enough, and have your experts available if something comes up and I need them. But that is not really necessary, even though the defense was asking for that in their particular motion. This is where it's good. The defendant's response to the state's motion limine, neuropsychology and psychiatric evidence. The state objects to the proposed testimony of Rachel Orr and Eileen Ryan, and arguing that the proposed testimony is outside of the mental condition evidence allowable under Idaho Code 182073. This response is made pursuant to IRE, Idaho Rules of Evidence 106, for complete defense and a fair trial guaranteed by the 5th, 6th, and 14th Amendment of the United States Constitution. The minute that the jury selection begins, jurors will begin to study and analyze Mr. Kohberger's physical presence. They will watch his every move and pass judgment on him on every minute of the jury trial simply based on how he looks and reacts to the presentation of certain evidence and comments about him. Mr. Kohberger must be able to present testimony to the jury that he has certain physical disorders. It will assist the trier of fact to know his physical presentation, including nonverbal reactions in the courtroom, is explained by his physical condition. To exclude this evidence will result in an unfair bias that would cause a wrongful conviction. The objection is supported by the declaration of Dr. Jeffrey Lewine, an expert neuroscience and neuroimaging. Mr. Kohberger in no way suggests that the expert testimony related to his autism spectrum disorder, obsessive compulsive disorder, and developmental condition disorder are for the purpose of showing that he does not know right from wrong. He has at all times and continues to assert his actual innocence in this case. The state correctly noted in its motion, Mr. Kohberger's disclosure states that Mr. Orr's testimony and Dr. Ryan's testimony is not intended to be a mental element defense pursuant to Idaho Code, but rather this testimony about state of mind as well as the factual testimony to anticipated testimony elicited by the state. Idaho Code 18207 is not limited to the admission of either direct or rebuttal expert testimony elements of the crime. The threshold test for the admission of expert testimony is whether the scientific or otherwise specialized knowledge of the expert will assist the trier of fact to understand or determine a fact in issue, pursuant to Idaho Rules of Evidence 702. Does this sound familiar, ladies and gentlemen? We talked about 702, specialized training and knowledge. The function of the expert is to provide testimony that is beyond the common sense experience and education of the average juror. Where the normal experience and qualifications of a lay juror permit them to draw proper conclusions from given facts and circumstances, then expert conclusions or opinions are inadmissible. In this case, it is not in the normal experience and qualifications of lay jurors to understand the ASD, OCD, and developmental coordination disorder. Expert testimony is necessary. Then they go into the anticipated testimony of Dr. Orr and Ryan is relevant to explain that Mr. Kohberger's ASD diagnosis is a physical condition and how much it presents in his demeanor. Mr. Kohberger has met the criteria for this diagnosis since childhood, and that is not a convenient diagnosis given his current legal situation and jeopardy. The anticipated testimony of Dr. Orr and Dr. Ryan is relevant to explain how the behaviors and mannerism presented by Mr. Kohberger are consistent with an individual having ASD. In addition to the opinions of Dr. Orr and Dr. Ryan, the declaration of Dr. Lewine explains the neuroimaging of Mr. Kohberger's brain supports his diagnosis that ASD, a neurological disorder that is physical. While most people ordinarily think ASD is a mental health condition, it is a neurological and developmental disorder. It goes on. And then he goes, some of the basic things that they want to be able to explain to the jury are the social communications and social interaction behaviors may include making little or inconsistent eye contact, appearing not to look at or listen to people who are talking, infrequently sharing interests, emotions, or enjoyment of objects or activities, including infrequently pointing at or showing things to others, not responding or being slow to respond to one's name or other verbal bids for attention, having difficulties with the back and forth conversations, often talking at length about a subject of interest without considering social cues or conversational give and take, displaying facial expressions, movements, and gestures that do not match what is being said, having an unusual tone of voice that may sound flat, lacking emotion or tonal variations, having trouble understanding another person's point of view or being unable to predict or understand other people's actions, difficult adjusting behavior to different social situations, and difficult sharing in imaginative play or in making friends. Restrictive, repetitive behaviors may include repeating certain behaviors or having unusual behaviors, such as repeating words or phrases, having a lasting, intense interest in specific topics, such as numbers, details, or facts, showing overly focused interests, such as with moving objects or with parts of objects, becoming upset by slight changes in a routine and having difficulty with transition. And then autistic people often have sensory differences, such as being more sensitive or less sensitive than other people to sensory inputs, such as light, sound, clothing, or temperature. People with ASD may also experience sleep problems in irritability. Then as it relates to the obsessive compulsive disorder, they want to be able to basically say that while testimony related to these topics may not be relevant until the state opens the door by eliciting testimony of these issues, once it does, Mr. Kohberger must be allowed to provide expert testimony in refuting the state's witnesses. Such relevant evidence can assist the trier of fact. Then we get to the developmental coordination disorder. Mr. Kohberger suffers from deficits in fine motor dexterity and visual motor function. Clearly, these are physical issues. He has experienced these physical impairments all his life. The state has disclosed evidence that law enforcement will testify that they did test runs at 1122 King Road and that it is possible to commit 4 homicides in a time frame of only minutes, including walking to and from a car and removing clothing that would be covered in blood. Additionally, the state has disclosed a forensic pathologist who will testify regarding manner of death, injuries, and specific wounds on the deceased. Mr. Kohberger has disclosed a forensic pathologist who has some differing opinions, including injury and specific wounds on the deceased. It will be relevant for the jury to know that Mr. Kohberger has a developmental condition disorder that impacts his fine motor dexterity and visual motor functions. Such speed and coordination are simply not possible for him. And in conclusion, Mr. Kohberger has a right to confront these witnesses and evidence presented by the state and under the due process. And the defense says the state should deny the motions in limine to exclude the neuropsychological and psychiatric evidence. More specifically, the court should allow Dr. Orr and Dr. Ryan to testify, and the physical disorder of ASD should be allowed at the outset of the trial. Issues relating to his OCD symptoms that are an outgrowth of his neurological disorder. So we want to be able to explain why he's going to be maybe making weird facial movements, looking disinterested at the trial, but also because of his dysfunction, his coordination disorder, he could not have committed the crimes. I think a lot of that can be addressed as it relates to mannerisms, simply in voir dire. I remember once I represented a guy who had tattoos all over his head and face, and obviously he looked a little scary to the jury that we were trying in Denver. And, I couldn't ignore it. So I brought it up and said, hey, as you can see, my client, who is an artist, uses his body as a canvas. Does that, freak anybody out? What do you think of it? People are like, oh my God, I think it's art. But you got to get it out there. Bring it out in voir dire. Next, we have defendant's response to the state's motion in limine, improper death penalty comments. The jury selected to try Mr. Kohberger's case will be aware the state is seeking the death penalty. They will be informed at the outset of a variety of reasons. Mr. Kohberger must have a way of conducting voir dire with prospective jurors. He must be able to examine witnesses and present argument as trial. And they suggest he uses phrases that comport with existing language in statute and jury instruction. Basically, what it is you have to qualify the jury to be death penalty qualified, so you're going to have to use words like murder and death penalty. Next, the defendant's response and objection to state's motion in limine, immediate family members in the courtroom. The defense objects to the state's motion in limine regarding immediate family in the courtroom. Specifically, the state asks for the court for guidance on which immediate family members are allowed in the courtroom for the entirety of the trial. Mr. Kohberger objects to this request on the basis that it is too narrow in scope and the court's guidance should be broadened to address the topics below. And then they go through the first, the individual identified by the state. Family members of the victims include mothers, fathers, stepfather, brothers, sister, and stepsister, and grandmothers. Acknowledging the term immediate family is undefined in the statute, and it says what is immediate families. The statute was obviously poorly drafted by the legislature, and obviously the term immediate family is susceptible to various interpretations. Then they go through all these different analysis of definitions and basically saying, hey, following this logic, it is likely that step-parents are relatives related by marriage. That would be included in the immediate family. In the recent Vallow Day bail trials held in Ada County, grandparents of the victims remained in the courtroom throughout that, even though statutory definitions, case law, and local practices combined would allow for family members. Second, Kohberger respectfully requested the court's guidance outline proper courtroom decorum, which discourages spectators from wearing t-shirts, example t-shirts with a picture of the victim. Okay. Little word of advice, ladies and gentlemen. I don't know what it is. Somebody dies. People always want to show up with the victim's family on a t-shirt. No. First of all, looks tacky. It's not appropriate for court, particularly when there is a jury trial going on. I've seen judges tell people to turn those shirts inside out. I totally agree with the defense on this one. All right. That's just ridiculous. Anyway, defense is objecting to object on that one. Defense replied to state's opposition emotionally regarding excluding IGG evidence. The state agrees to the outcome of the motion and has agreed to not present any evidence of the IGG process, which I think is very interesting. Obviously, that the defense originally tried to bring up all the IGG stuff, saying that was the basis for the misconduct, motions to suppress the search warrants and anything obtained from the search warrants. And now they're like, we don't want to go there at all. Let's not focus on it. Next, defendant's objection to state's motion in limine, text messages. This is what we talked about. All right. See, this is why you got to dig deep. I've read a lot of stuff about all these other cases and analysis that people have. For example, like the whole defense of he couldn't have physically done the crime because of his coordination disorder. I don't think anybody else has talked about that. All right. Like I said, defense objection to state's motion in limine. Kohberger, through his attorneys, motion in limine to admit text messaging as requested. Law of the case. The state relies on judge conclusion in Mr. Kohberger's challenge to the grand jury indictment. However, that decision doesn't bind this court. The law of the case doctrine applies where an appellate court pronounces a principle of law necessary to the decision. When considering whether or not the text messages is either an excited utterance or a present sense impression, the court will have the benefit of additional information that wasn't previously available. Even if the court determined judge's decision was the law of the case, this court has discretion to hear and decide the issue presented before the court. The trial court's discretion to change its own pretrial ruling, especially evidentiary rulings. The state seeks admission of certain text messages to the rules of hearsay. Excited utterance. Excited utterance has two requirements. One, an occurrence or event sufficiently startling to render inoperative the normal reflective thought process of an observer. And two, the statement of the defendant must have been spontaneous reaction to an occurrence or event and not the result of reflective thought. We've talked about this, ladies and gentlemen. It's like you have taken evidence before. If you watch this program, you get evidence. We talk about this all the time. What is an excited utterance? We've talked about this. The court needs to consider the totality of the circumstances, including the amount of time that has elapsed between the startling event and the statement, the nature and condition of the event, the age and condition of the declarant, the presence or absence of self-interest, and whether the statement was volunteered or made in response to a question. Present sense impression. Although the rule does not expressly state, factors trustworthiness and necessity play a large role in the trial's court's determination whether to admit a declarant's expression of his state of mind or whether to exclude it under Rules of Evidence 403, as well as the decision whether to admit or exclude the content of additional statements accompanying that expression. Both exceptions require these statements to be contemporaneous with an event and be spontaneous without the time for reflection. They go on, Mr. Kohberger provides more complete but not exhaustive view of the DM and BF's communications and interactions with social media during the hours established by the state. They go through several pages of them. I'm not going to go through these. We've talked about some of these before. No one's answering. What was going on? Come to my room, etc. Anyway, the defense argues that the state has selected text messaging as excited utterance and present sense impression. The totality of the circumstances defeat the state's request. BF and DM text each other over a handful of times, and they were in the same bedroom. They were together and the ability to talk to each other. They were not asleep for 8 hours. The message that state seeks admissions of exceptions to hearsay began with a call and message about being confused. After texting each other and unsuccessfully speaking with any of the roommates, the state is looking at the messages with the benefit of hindsight. The analysis has to be done in the moment the excited utterances were made, text messages in this case. DM first claimed confusion, then after communication with BF, claimed fear of leaving her room. Despite her stated fear of leaving her room, she does so and joins BF downstairs. To get to BF's room downstairs, DM passed the front door of the residence. BF was steps from the front door. Neither of them left the house. Neither of them called friends, family, or law enforcement. Instead, both have a substantial amount of activity beginning at least 4 hours after DM made her way to BF's room. BF and DM communicate with friends and parents on social media. So basically what they're saying is, hey, since these two didn't either call the police or run from the house, this really wasn't such a startling or shocking event that the excited utterance exception should not come in. Now, frankly, they can testify as to what they did. So, but prosecutors like corroboration. Okay, what did you do? Well, and did you put that into communication to show, look, I'm not lying to the jury. Here's the corroboration to it. Anyway, the second group of messages the state claims fit within the exception to the hearsay rule are those from DM to her roommates beginning at 10:23 a.m., 6 hours later. The state claims DM woke up and realized her roommates had not responded to her earlier text. The state is wrong. DM was awake. She was messaging on Snapchat. She was on Instagram, and she texted with her dad. And she did this in an exhaustive list of activities on her phone. She was with BF, who was also communicating with her parents and then later friends. Mr. Kohberger urges the court to view the state's request with consideration of the complete picture. The state has asked the court to look at the timeline, and Mr. Kohberger urges the court to look at everything that occurred during that timeline. If I were the judge, I would say, all right, I appreciate you putting me on notice of this. We'll take it up at the trial and I'll rule on it, and you can make any contemporaneous objections that you desire. Admissibility of the demonstrative exhibit. Remember, the state wants to do a 3D demonstrative exhibit of the house where everything took place. And it says, upon learning the state intended to have a model of the crime scene built for demonstrative purposes in October of 2023, the defense requested specific discovery. And then they cite the time. None has ever been produced other than a single police report discussing the intent to build a model. After the discovery deadline, the state sought a stipulation to the exhibit. Mr. Kohberger declined. The state disclosed a drawing, alleging it is a drawing of a model that will be built. It was only 3 days ago that it was disclosed who is building the model, the credentials of those who are building the model, and the data underlying the model. The state's expert disclosures did not discuss the use of a model. In order to ensure that this is a fair and accurate model, the defense would need to hire its own expert to evaluate the model once it's done. Conduct independent investigation into the underlying data, potentially develop more or different evidence, and then litigate the admissibility of the specifics of the model based upon the investigation. The state has delayed this for too long. Despite specific requests for discovery and knowledge of the upcoming trial date, that has prejudiced Mr. Kohberger's ability to investigate and challenge the model, and it should therefore be excluded. The state produced a discovery file regarding the demonstrative aid. The discovery file is massive, containing materials that require an expert to open and read them. These are 3D scans Mr. Kohberger has asked for over a year. The new discovery contains documents that indicate the state has been working on this since late 2023. The state's extremely late disclosure of what Mr. Kohberger requested at the time of learning about the state plans violates Mr. Kohberger's right to a fair trial, effective assistance of counsel, and due process. This discovery is more than 6 months past the date's discovery deadline, 3 months past expert disclosures, and a limit over 4 months until trial. The state must not be allowed to violate Mr. Kohberger's rights, ignore the Idaho rules of criminal disclosures under Rule 16, and the state cites a couple of cases, and the demonstrative aid was where they try to give examples. The state properly acknowledges that the requested demonstrative evidence must be subject to Rules of Evidence 403, and it must be relevant under 401. The aid, a model constructed in an undisclosed way, is not relevant, and even if it was relevant, it is unfairly prejudicial, cumulative, confusing, and misleading. The state has thousands of photos of the house, 3D imagery, and multiple witnesses have been inside the house. Evidence produced in the manner allows a jury to evaluate it using their common sense and experience. Nothing in the law the state relies upon supports disregarding Mr. Kohberger's rights to discovery. Therefore, Mr. Kohberger does not have the opportunity to confront the evidence through prepared counsel and informed experts. Allowing such evidence violates Mr. Kohberger's rights. I get the defense. Listen, I've been there, done that. I've made those type of objections. It's a demonstrative aid. One could draw a picture of the house. They could have the detective draw a picture of the house and outline the way that he walked through the house. That is a demonstrative aid. I will bet you the biggest stake in Denver that demonstrative model comes in, and the defense can then challenge whether they think it's to scale or not. All that's going to be laid out when they do it. Challenge it in front of the jury. Well, isn't this not to scale? Or they're going to decide not to challenge it because they're going to look silly if they're saying, you mean they took all these 3D imaging, they did all this measurement, and they hired somebody to do this so that we can look at it and, doesn't go back to the jury room, helps explain the testimony? The judge is going to allow that in. Bottom line. Objection to the state's motion in limine regarding AT&T time advance records. Mr. Kohberger's rights are founded in the constitutional guarantees. The state's motion seeks to prevent Mr. Kohberger from confronting, through a full and fair cross-examination, a portion of the case. The state seeks Mr. Kohberger's silence on records produced by AT&T time advance records. The state motions informs the court TA records were not produced by AT&T Global Legal Demand Center until May of 2023, and Mr. Kohberger agrees with the claims. However, that is only the partial information. The state is misleading this court in its motion by what it leaves out. What it says is not saying is that the TA records existed at AT&T in November and December of 2022. The state has to know this to be true because in April of 2024, the state produced the actual records from AT&T for cell towers and individual TA records for 2 of the 4 deceased and 1 for a person who has been a person of interest at the beginning of the investigation, as well as over 3,800 people on the cell tower. These records were from November of 2022 and were produced to discovery in Mr. Kohberger's case in 2024. It is accurate that AT&T Global Legal Demand Center did not produce TA reports to law enforcement in 2022. The TA reports from AT&T GLDC were not available to the state and local law enforcement until June of 2023. However, the existence of these reports in this case is a direct evidence that these records could be and were provided to law enforcement by AT&T prior to the production through the GLDC. AT&T and TA reports prior to their availability through GLDC, the state's attempting to do this. All right. What they say then is Mr. Kohberger's TA records are different than the other records provided in discovery. The records are location data that are accurate in determining the location of the cell phone. TA is a term used in the cellular network industry relating to a measurement of time. It measures the time it takes for a radio frequency signal to travel between a mobile device and a base station in a cellular network. TA is required in cellular networks to assign a time slot to a mobile device, allowing it to transmit data so that it doesn't interfere with other devices. Given this signal is traveling at a known speed, the speed of light, 299,792 kilometers per second, it is possible to use timing information to determine the distance of the mobile phone from the base station. These measurements can be very accurate. When a mobile device is using multiple cell sites, it is possible to utilize trilateralization to determine a very specific location, typically ranging in meters. Essentially, TA records provide a much greater detail of accuracy than regular cell site location information, only providing cell site and cell sector information. When analyzing a pattern of life associated with a mobile device, TA can provide accuracy in such detail it is possible to pinpoint precise travel routes, stagnation, and anomalies within a pattern of life. Law enforcement commonly relies on TA records for this purpose. The methodology and accuracy is supported through established, published, and accepted scientific practices. Then it goes on about these come at great expense, but AT&T's developed a new system outside of their Arius Geo system to produce these records at a fraction of the cost. This cost reduction allows AT&T to provide these records to state and local law enforcement. As a result, GLDC was given access to TA reports in May of 2023 and began providing them to state and local law enforcement in June of 2023. The distinction is that AT&T TA records were available to only a select law enforcement, specifically the FBI, well before the internal change. Mr. Kohberger is aware of the fact that AT&T GLDC did not produce TA records in 2022. There is no doubt any representative from AT&T will testify to this fact. Mr. Kohberger does not contest this claim. The state is also aware of this, that they did not obtain the current AT&T TA records in their possession through AT&T GLDC. They had to utilize the FBI, who went through a different legal compliance unit within AT&T to obtain those records. At the onset of the investigation, detectives with the Moscow Police Department began obtaining call record details part of the investigation. In doing so, they heavily relied upon the assistant from Special Agent Nick Balance with FBI CAST. This is the first documented emails exchanged in November 15th of 2022. Detective Lawrence Mowry and Brett Payne were tasked with writing search warrants to AT&T for a number of requests. On November 15th, 2022, Detective Mowry requested verbiage via email from Special Agents Balance in reference to the records. An email string that was produced by the state and discovery contains a very clear account of Special Agent Balance's knowledge of AT&T TA being available. In reviewing the email, there's no doubt in the email is reference to AT&T. Detective Mowry then forwarded Special Agents Balance email to Prosecutor Ashley Jennings. Detective Mowry was informing Prosecutor Jennings of the availability of AT&T TA records and reports and requested to be added to the warrant. In reviewing the AT&T search warrants that were produced over the next few days after the email chain, all of them contained specific verbiage requesting to AT&T TA reports just as recommended. While the email chain is clear as to the existence, availability, and knowledge of availability to the state regarding these records, in July of 2024, Mr. Kohberger received from the state AT&T TA reports from 2022 in reference to this investigation. These TA reports were not for his phone. The state turned over 3 separate reports. All 3 contain AT&T TA data from November of 2022. In the early phases of the investigation, law enforcement identified 3 AT&T phones of interest. 2 belonged to deceased, and third phone belonged to a person of interest whom law enforcement was investigating as a suspect. Detective Mowry authored an affidavit in support of a search warrant to AT&T issued on November 16th that demanded the AT&T TA records of the phone. All 3 TA records were produced by AT&T and are currently in the state's possession. Mr. Kohberger is aware and will provide testimony in support that the AT&T timing reports currently in the state's possession were not provided by the state. The reports were produced through other compliance units with AT&T. Mr. Kohberger persists that relying on GLDC stating that they did not provide TA reports in 2022 misses the issue at hand. Throughout the discovery process, state has provided different explanations about TA reports availability, but always claims that it was not in their possession. The state obtained search warrants in December 2022, and the state sought the AT&T TA reports from Mr. Kohberger from November of 2022. The search warrant for Mr. Kohberger's phone data contained identical verbiage and used requesting TA reports in the warrants. They've sought the warrants, therefore, Mr. Kohberger has a right to confront the evidence in this case. His constitutional protection mean he must be afforded the full opportunity, fair fair opportunity to cross-examine the state's witnesses. AT&T TA reports are available. The state has produced reports that they were prepared, and basically they want them. Interesting. The accuracy they're trying to show, obviously, that he wasn't there. Objection to the state's motion in limine regarding alternative perpetrator evidence. Remember, the other people did it. Kohberger, through his attorneys, respond to the state's response. The state seeks an order prohibiting Mr. Kohberger from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant to the admissible pursuant to Rules of Evidence 401, 2, and 3. For the reasons set forth below, Mr. Kohberger objects to this motion. Mr. Kohberger has a right to present a full and fair defense, blah, 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 blah. The state argues that literally thousands of tips regarding possible perpetrators were reviewed by law enforcement during the course of the investigation, and that none of those tips were substantiated with the exception of information regarding the defendant. The state is correct that over 45,000 tips have been disclosed and tips continue to come in daily. The case is full of alternative perpetrators. The state has chosen to focus on Mr. Kohberger at its own peril. Mr. Kohberger will produce offers of proof related to many alternate perpetrators in this case that will meet the Idaho Rules of Evidence 401, 2, and 3 standards. Many alternate perpetrators can be connected to the crime. The court should deny the state's motion in limine regarding alternative perpetrator evidence. Alternatively, the court should reserve ruling on this motion until Mr. Kohberger provides an offer of proof, and the court can then evaluate the standard. So obviously the defense says, hey, there's lots of other people that could have perpetrated this crime, and the prosecution only focused on Mr. Kohberger. So therefore, it's at their peril, and we get to talk about the other things. Really what's going to talk about is the other things in the investigation. You had all these 4,500 tips. You didn't really pursue them. You didn't get search warrants for those individuals, did you? No. You decided it was Mr. Kohberger and you focused on him. That's where the defense is going to go on that. Next, objection to the state's motion in limine regarding the alibi. This is going to be good, ladies and gentlemen. All right, Mr. Kohberger filed a response to the state's request for discovery, disclosure, and alibi demand on June 9th of 2023 and contemporaneously filed a motion for an exception or in the alternative to extend the time for compliance. The state filed a response to our motion, an extension of June 13th of 2023. Mr. Kohberger filed his notice of alibi on July 24th, 2023. The notice stated that at the time alleged by the state that he was inside the King Road home, he was driving his vehicle and not in Moscow. The state filed a motion to compel on July 27th, and hearing was held on August 18th of 2023. The state provided a partial transcript of the hearing in the motion in limine. Subsequently, speedy trial was waived, and a scheduling order was vacated pursuant to the new scheduling order. Idaho Code 19-519 governs notice of alibi and requires specific names and places to verify where a defendant was at the time of the crime. Mr. Kohberger advised the state he intended to offer expert testimony through Ray, a partial corroboration that he was driving south and west of Moscow, Idaho during the early morning hours of November 13th of 2022. The expert testimony involves cell site location information. Mr. Kohberger further advised the state of his intention to cross-examine any state expert in that field. And after that disclosure, the court heard Mr. Kohberger's fourth motion to compel, wherein, among other things, Mr. Kohberger sought further records related to the cell site location information. Mr. Kohberger called Mr. Ray to testify at the hearing, and the state declined cross-examination. The state provided records necessary for the cell phone location information in various batches of discovery. The records consist of call detail records from AT&T, cell tower lists, and drive test data. The state provides its cast draft report and later a final report. However, no analysis has been provided. The state did not produce a timing advance report for Mr. Kohberger's cell phone. Partial corroboration does not cover the time alleged in the state's charging documents or in any affidavit in support of searching and seizing Mr. Kohberger's person or property. Partial corroboration relates to where Mr. Kohberger was during the early morning hours of November 13th of 2022. Interesting, because they're saying we can't say during the time that the murder took place that he wasn't there. We're we're providing partial corroboration of our alibi. Anyway, the state cites the various case law to suggest that Mr. Kohberger is hiding a witness that will prejudice the state. This is not the case. Mr. Kohberger has stated exactly how he will partially corroborate where he was. He will use information contained in the discovery supplied by the state, and he will present his testimony of expert witnesses, Cy Ray. Mr. Kohberger has met the statutory obligation in providing the notice and the corroboration. That's the alibi. I was driving, looking at the stars, and they're going to have an expert to partially corroborate it. Obviously, if there was something to say that during the time of the alleged murders, he wasn't there, they would have produced that. In this case, would have gone away. Make and model vehicle suspect. This is the motion regarding make and model of vehicle suspect. Facts. On November 13th, Moscow Police Department responded to 1122 King Road. Investigators found 4 deceased individuals who died from apparent stab wounds. Investigators canvassed the crime scene area for surveillance footage to identify the person responsible for the homicide. A surviving roommate, DM, reported to law enforcement she was woken around 4 a.m. by noises. Investigators were able to obtain surveillance footage from 1112 King Road, a residence immediately to the northwest of the crime scene. That video surveillance picked up audio of voices or whimpers followed by a loud thud. In addition, a dog can be heard barking at 417. DM reported around this time she saw an unknown male in the residence walking towards the rear exit of the residence. And the 1112 King Road video shows a white sedan entering the crime scene area at 4:04 a.m. The same white sedan is seen departing the crime scene area at 4:20 a.m. at a high rate of speed. Based upon this information, investigators focus on identifying the make and model of the white sedan, seen on the 1112 King Road surveillance. The suspect vehicle is seen on the 1112 King Road surveillance prior to the homicides, and video surveillance capturing the suspect vehicle was collected at additional places near the crime scene prior to the homicide. 1311 South Main Street, also known as the Sunset Mart, 1125 Ridge Road, 0.4 miles from the scene, and at 1320 Linda Lane, 0.2 miles from the crime scene, 1330 Linda Lane, 0.3 miles from the crime scene, at 330, 339, 356, 405, and 407, and 451 Paradise Drive, 0.6 miles from the crime scene, and 3:35 a.m. and 3:48. FBI report of Special Agent Rob Hill, pages 1 through 10 attached as State's Exhibit S2. Google Maps, 5 pages attached as State's Exhibit S3. Investigators were able to review those videos and determine the route of travel. Investigators provided video footage to the Federal Bureau of Investigation to determine the make and model of the suspect vehicle at the 1112 King Road surveillance. Forensic examiner Anthony Immel reviewed multiple videos and still images, and according to Immel's report, the multiple submissions of media were reviewed independently and collectively to identify the questioned vehicle's make, model, and year. FBI's report of Special Agent Anthony Immel attached as State's Exhibit S4. Of those videos, the 1125 Ridge Road video provides a clear view of the suspect vehicle. Make model chart number 3 attached as Exhibit S5. Immel was able to compare this video to the video of the 1112 King Road. The video was captured at 4:01, approximately 3 minutes prior to the suspect vehicle entering the crime scene at 4:04 a.m. Hill report at pages 8. Regarding the questioned vehicle, the vehicle on the 1112 King Road surveillance, Immel's opinion is the questioned vehicle shares similar class characteristics with a 5th-generation Hyundai Elantra between 2014 and 2016. The similar class characteristics include, but not limited to, the overall body style, window configuration, front grille configuration, headlight shape, side trim, rear brake light configuration, rear license plate position, and rear bumper position. The position of the rear bumper reflector and the shape of the fog lights assisted in the narrowing of the vehicle year span. And that was at the Immel report pages 2 and 3. A white 2015 Hyundai Elantra was registered to the defendant at the time of the homicide. Washington vehicle registration attached. The state's expert report regarding the identification, Anthony Immel should be allowed to explain to the jury his opinion that the suspect vehicle on the 1112 12 King Road surveillance shares similar class characteristics to a fifth-generation Hyundai between 2014 and 2015. The suspect vehicle was identified from surveillance footage from the area of the crime scene. The defendant claims that the suspect vehicle was not identified from surveillance footage in the area of 1122 King Road. This simply is not true. As stated in Immel's report, multiple submissions of media were reviewed independently and collectively to identify the questioned vehicle's make, model, and year. The suspect vehicle was picked up on multiple occasions, at least 6 separate locations, all within 0.6 miles from the crime scene, immediately preceding the crime, i.e. less than an hour, as indicated below. And they give a little map of all of the locations where he was spotted around the area, allegedly. The video captures footage in the middle of the night from approximately 3:35 a.m. to 4:07 a.m. when there is a light vehicle traffic, especially in Moscow, Idaho. From the review of the surveillance video, investigators were able to determine the suspect's vehicle path to travel based upon the witness directions of travel associated with the timestamps. And from the review of the 1125 Ridge Road video, which admittedly provides the best view of the suspect vehicle, investigators were able to determine that the suspect vehicle shared similar class characteristics to a fifth-generation Hyundai Elantra. The video taken at 4:01 a.m., approximately 0.3 miles from the crime scene, and based upon the 1125 Ridge Road surveillance and the other video surveillance, investigators can determine the suspect's path of travel as follows. It takes approximately 3 minutes to travel from 1125 Ridge Road to 1112 King Road. A logical application means the vehicle with characteristics of a fifth-generation Hyundai Elantra is the same vehicle on the 1112 King Road camera at 4:04. The same line of reasoning can be applied to other surveillance video. The state should be able to introduce all video surveillance surrounding the crime scene preceding the homicides. The state's experts should be able to opine based upon his analysis and the surrounding circumstances that the surveillance is picking up the same vehicle. There does not need to be continuous footage for the evidence to be admissible. Defendant argues there is no continuous footage linking this vehicle at the 1112 King Road footage and that from the Ridge Road. Defendant's motion, page 3. Defendant's argument appears to suggest that because every single business and residence surrounding the crime scene did not have video surveillance, the state should be precluded from introducing this evidence. This is illogical. As argued above, the state should be able to introduce all captured video surveillance of the crime scene preceding the homicide. The state's experts should be able to opine based upon his analysis and surrounding circumstances that the surveillance is picking up the same suspect vehicle. This opinion would not be speculative, as argued, but instead based upon logical, educated inferences from the review of the surveillance video, including observed traffic flow, direction of traffic, and timestamps. Identification of the suspect vehicle is relevant. As the court has seen, defendants, others filing, the defendant tends to label bad evidence for the defendant as irrelevant and asks this court to prohibit the state from introducing it. That is not the rule. Under Idaho Rules of Evidence 401, evidence is relevant if it has the tendency to make a fact more or less probable that it would be without the evidence, and the fact is a consequence in determining the action. The evidence is clearly relevant as the defendant owned a 2015 white Hyundai Elantra at the time of the homicides. Defendant argues pursuant to Rules of Evidence 403, this relevance evidence should be excluded. The defendant fails to show how this evidence is unfair, confusing, misleading, would cause delay, waste of time, or would be cumulative, much less that the evidence is probative value is substantially outweighed by such. While the evidence is prejudicial, relevant evidence tends to be, it is not unfair. How many times have we talked about that, ladies and gentlemen? The defense objects that this evidence is prejudicial. It is devastating to our defense. That's basically what they're saying. The state anticipates Mr. Immel will testify in accordance with his expert opinion at trial. And basically, yeah, that's coming in. And then they attach the statement of Brett Payne, who was qualified as a peace officer, what he did during that time period. Basically, we also have the surveillance review of the cars from the Federal Bureau of Investigation. So we have the report attached as well. So this is where the good stuff starts coming in. This is where, the defense and prosecution have to start attaching relevant evidence so the judge can make these pretrial determinations of what is coming in. And this is a question of fact for the jury to decide. The jury The jury, ladies and gentlemen, gets to decide whether that was Mr. Kohberger's Elantra that they are saying was the getaway car for the murder or not. But it is relevant, and so it's coming in, and the defense will have an opportunity to cross-examine on that. We'll do this one, then we'll do one more. We'll save the next for the next day, I guess. This is the state's response to defendant's motion to eliminate conditions of aggravators, all right? The prosecutors do the little introduction and the defendant's autism during the penalty phase. All right. The motion limited regarding the state's use of defendant's autism during the penalty phase of the trial. Defendant asked this court to prohibit the state from asserting autism or any symptom of autism as an aggravating factor that would support imposition of the death penalty. The state has no plans to rely on defendant's autism as an aggravating factor at the penalty phase of trial. However, the law is clear that the state can argue against and rebut defendant's alleged autism diagnosis to the extent the defendant relies on his autism diagnosis as a mitigating factor. Thus, the court should deny the motion. Anyway, they go some case law about aggravating factors. And then they talk about a Kuntz, United States v. Kuntz. The defendant presented during the trial phase of capital evidence about whether the Bureau of Prisons could control him, and expert testimony on how this brain injuries might mitigate his role in the offense. Anyway, consistent with the decisions, the Idaho Supreme Court has been clear. Mental illness, like all mitigating factors, warrants only the weight the jury sees fit to give it. In Dunlap, which is a case, the court upheld the removal for cause of a juror who said he could not give the death penalty if there was evidence of any sort of mental problems. The court found the jury was properly excluded because the view would substantially impair his ability to perform his juror duties, including decide whether the imposition of the death penalty would be unjust by weighing all mitigating factors. The juror's statement that there was any evidence regarding mental illness, he could not impose the death penalty. Then they go on and basically said none of the four circumstances relate to the defendant alleged autism. Indeed, the states filed the amended notice prior to having knowledge of the defendant's alleged autism. But if the defendant relies upon his alleged autism as a mitigating circumstance, that could be rebutted by the state, consistent with the Zant, use defendant's autism to rebut mitigating evidence and argue the weight the state believes the jury should give it. So be careful what you wish for. If you're going to use autism as a somehow defense, guess what? The prosecution can come back and use it against you. Another good one. I've got two good ones. We're going to have to do them. One is the state response to defense motion in limiting number 9 to exclude the Amazon click activity evidence at trial. This is the purchase of the knife, ladies and gentlemen. They give the background on November 13th. They responded. There were 4 people died of apparent stab wounds. A K-bar knife sheath with the United States Marine Corps logo was found. There it is. There's a little logo. I don't know if you can see that. After all those years, still there. Was found lying next to one of the victims. Bryan Kohberger's DNA was found on the K-bar knife sheath on the scene. The state applied for and was granted a search warrant for Bryan Kohberger's Amazon.com user activity. The search warrant was amended by a magistrate judge on May 8th to correct a Scrivener's error. The amended search warrant dated May 8th, attached as State's Exhibit S2, the search warrant directed law enforcement to seize from Amazon Bryan Kohberger's customer click activity pertaining to knives and accessories, payment method used, detail of items in cart to include all items added to cart, all items removed or deleted from cart, wish list or shopping baskets, all suggestions made to account, and all records regarding reviews by Amazon users, viewed by Bryan Kohberger, advertising data, device used in connection to the account, and all accounts linked to the individual. The search warrant was limited to March 20th, 2022, and March 30th, 2022, and November 1st, 2022, through December 6th, 2022. The search warrant was served on May 10th. On June 27th, Amazon provided law enforcement responsive data for the dates requested for each of the above categories. That's been produced to the defense. On December 18th, the state disclosed Shane Cox, litigation and regulatory manager, law enforcement response for Amazon.com as a witness for the above evidence. As articulated in the disclosure, it is the state's position that Shane Cox's testimony is not expert testimony pursuant to 701. However, out of an abundance of caution, they endorsed him as a witness under 702 and 703. The state made this strategic decision solely to ensure the state was not precluded from calling Mr. Cox as a witness if the court subsequently made the determination that his testimony based upon specialized knowledge. Then they go through, here's the law about Rule 106, doesn't apply to business records containing user activity records. Talk about how the narrow scope of it. And then Bryan Kohberger's Amazon.com click activity is relevant. Under 401, it's relevant. It's not prejudicial under 403. And this is the good part right here. Page 5 of the motion. Applying the test for relevancy, first, Kohberger's click activity, which shows a purchase of a K-bar knife and sheath before the homicides, makes it more probable than it would be without the evidence that the K-bar sheath found at the crime scene was Bryan Kohberger. Second, Kohberger's click activity after the homicides makes it more probable than it would be without the evidence that Kohberger had a reason to search for a K-bar knife and sheath after the homicides. These facts are a consequence of determining whether Bryan Kohberger committed the homicide at 1122 King Road, the central question before the jury. The evidence is clearly relevant. Defendant argues, pursuant to 403, the relevant evidence should be excluded. The defendant fails to show how this evidence is unfair, confusing, misleading, would cause delay, waste of time, or would be cumulative. That is because it is none of those things. What is clear from the defendant's filing is the defendant doesn't like this piece of the state's evidence. Defendant's Amazon click activity, and therefore would like to keep this piece of evidence from the jury. However, this argument is without merit, and while the evidence is prejudicial, relevant evidence tends to be, it's not unfair. Boom, ladies and gentlemen. And then they attach the search warrants. He bought a K-bar. What are the odds? What are the odds? The guy that buys a K-bar, I'm sure they're going to have evidence that was shipped to his house, that he received it. His sheath just happened to be at a crime scene, and they can't find that pesky knife itself. That's what the prosecution is going to be arguing. What are the odds? And I know the defense is sitting there talking to their clients, say, what are the odds? How do we make this go away? Well, it's prejudicial, Your Honor. My God, that fact that he bought the K-knife, the knife, which is suspected to be the murder weapon, the instrumentality of 4 deaths of 4 young people, just happens to not be able to find his knife, but the sheath was found there. And I bet the sharpener was found at his apartment. Yeah. Ladies and gentlemen, bad news for Bryan Kohberger. All right. Next one. Witness identification by bushy eyebrows. The state of Idaho, through their attorneys, response to defendant's motion in limine regarding bushy eyebrows. Defendant's basis for his motion is on Idaho Rules of Evidence 403, 601, 602. Applying the Idaho Rules of Evidence to the facts of this case at hand, the court should find DM's description of the intruder, including that he had bushy eyebrows, admissible. They incorporate all their previous motions and the 911 call, etc. Not going to go through the facts again as it relates to the roommates seeing somebody that they described as a bushy eyebrow. And it's based upon a portion of the motion here why I don't think the court is going to allow an in-court identification. When there was a subsequent interview by the police on December 29th, when Bryan Kohberger was arrested in Pennsylvania, the following day, some 47 days after her first interview, DM was interviewed by Idaho State Police Detectives Joe Lake and Gary Tollinson in Coeur d'Alene, Idaho. Defendant's Exhibit 9, DM asks about Bryan Kohberger. DM was asked, have you seen a picture of Bryan Kohberger? DM responded, yeah, I looked him up today when I found out. Regarding what picture she saw, she stated, I've seen the mugshot, one with the vest thing, I think. The interview asks, this Bryan Kohberger, the person that you saw in the mugshot, is this the person you saw in your house? She responded, I have no clue. From what I remember, I just remember seeing this figure was like not fat, obviously, but more like a skinnier tone build and some mask on. I don't know what that mask exactly was. But when I thought about it, it was just like covering here and here. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember knowing that he was white, but I didn't know how he was white. I just knew he was. And Knowing this, I knew he had to be looked at me because of the bushy eyebrows. That's all I remember. But I have no idea what he looked like. I looked at his pictures, nothing came back to me at all. So I don't know. I feel like if I saw it, my mind would be like, oh yeah, that's him, but I just don't remember. Regarding DM telling BF that the male had a big nose, DM said, all I remember, but I don't remember big nose at all, at all. All I remember is bushy eyebrows and black and some sort of mask, but that's it. Anyway, so they go on and on and on. DM statements are independently reliable, and law enforcement did not employ witness identification procedures, triggering the Bigger's balancing test. That's basically suggestive IDs. If the witness goes and looks on her own, there's no police misconduct, and therefore basically saying this was an unduly suggestive identification is not grounds for that. Anyway, so the conclusion, the state respectfully requests this court to rule consistently with its previous findings that DM is credible and competent to testify, and allow DM to testify at trial regarding her recollection of the male she saw in her residence during the early morning hours of November 13th, 2022 as having bushy eyebrows, because that evidence is relevant and admissible. And then, of course, we get the photo today of Kohberger standing in his bathroom taking a picture, allegedly just hours after the alleged homicide took place. Really quickly, the DNA, the state properly disclosed their Mr. Nolan's initial disclosure and rebuttal disclosures. The state may have Ms. Nolan testify in its case in chief, but it may also wait until rebuttal, and that's regarding the DNA touch evidence. All right, we'll save the rest for tomorrow. Let's move on to the other news of the day. All right, next on the docket, Karen Read. Well, as you may recall, we talked about it yesterday. The defense wanted a continuance of the jury trial, and the prosecution said, I'm okay with that. Today at the hearing, the prosecution said that we didn't oppose it, but that was because for appellate purposes, they wanted to try to be accommodating. But the judge says, no, the retrial will continue as scheduled after the judge denied the motion to postpone the trial due to the federal appeal that's taking place as in regard to the habeas issue that has been denied by the trial court, the appellate courts in Massachusetts, the district court judge on a habeas proceeding, and now it'll soon be the First Circuit in the federal courts as well. So jury selection is going to begin on April 1st. And like I said, Reed's lawyers had asked that the jury selection be pushed back to April 28th while the federal appeals court in Boston considers the request to dismiss 2 of the 3 charges pending against Miss Reed in the death of her boyfriend, Boston police officer John O'Keefe. And the judge says, hey, I'm not going to grant it. Nope, not going to do it. As fastest decision she's made yet. Everything else seems to be taken under advisement. She said, we have jurors coming in. They've been summoned months ago, and we're going to start to impanel the jury on April 1st. She said that's going to take some time, and then she'll rehear the defense motion if the jury is selected before April 25th, and the federal appeal remains pending. But the judge said, hey, we're not going to swear in the jury because obviously that's when double jeopardy attaches, and if something were to happen, mistrial could be declared. They could declare manifest necessity for a mistrial. You just never know. Anyway, also at the hearing, both sides continued to argue over the government's attempt to obtain communications between Karen Read and Adrian Kearney, the blogger known as Turtle Boy, charged with intimidating witnesses in her case. Now, the special prosecutor, Mr. Hank Brennan, argued during the hearing that prosecutors in Kearney's case have obtained the material pursuant to a warrant, and now he's seeking permission to use some of it in the Karen Read matter in an effort to establish consciousness of guilt, right? Consciousness of guilt is where, you kind of apologize. Oh, I feel bad for something. You do things that are consistent with you feeling bad with something. It's almost like, flight. Why would somebody leave if they were innocent? That kind of thing. Anyway, Mr. Brennan argued and noted that Miss Reed in a television documentary discussed providing information about her case to Mr. Kearney, which he allegedly used to harass witnesses. Now, with a smile, he notes, she acknowledged the consequences of her actions and seems to encourage it, Mr. Brennan implied. As he spoke, Kearney, who was seated with his lawyer at the defense table as an intervening party, shook his head. Now, Kearney has pled not guilty to witness intimidation charges and says his actions were protected by the First Amendment. This evidence should be available to me, Mr. Prosecutor argued, saying the communications between Kearney and Reed should be able, and he should be able to access it. Reed's attorney, Miss Little, asked the judge to deny the motion. Now, another judge was hearing this issue because it's related to like taint teams and anyway, things about that. But it was the Judge Adam Sisiski. Anyway, he said the Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of the evidence, Ms. Reed's attorneys argued. And Kearney's attorney, Tim Bradel, also urged the denial of the government's motion. He said that under the state law, to get that material, Reed's prosecutors should have to show that they can't prepare for trial without it, and that the request is not a fishing expedition. And the judge took the matter under advisement. We'll see. Obviously, somebody doesn't want those disclosed because they apparently are good, just like we talked about in the Bryan Kohberger matter. Anyway, following another recess in the morning, the court took up arguments on a defense motion to bar prosecutors from calling Dr. Judson Welcher, a biomechanical engineer in crash reconstruction, as an expert witness at trial. Now, Welcher determined that lacerations on O'Keefe's right arm, which the defense contends came from a dog, is in fact consistent with a geometry and orientation of Reed's right tail light, according to the pleadings. Now, the defense plans to call experts who said at the first trial that O'Keefe's injuries weren't consistent with being hit by a vehicle. Those experts from the ARCA company were initially hired by the Justice Department as part of the federal probe into the state's handling of the case. And following the trial, they billed the defense $23,000 for their testimony. Now, in arguing for barring Welcher's testimony, Reed's attorneys said that the analyst relied in part on contested testimony from other witnesses to fashion his opinion. Welcher conducted an experiment involved painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. In addition, he said Welcher discussed evidence outside of his area of expertise, including pattern recognition on Mr. O'Keefe's wounded arm. Now, Mr. Brennan countered that Welcher's work was extraordinarily thorough and that he won't discuss areas outside of his purview of his testimony, and they'll have him on the stand to ask him any questions. The defense expert who testified at the first trial, Brennan said, mentioned a cannon they'd fashioned to conduct experiments in regards to simulating glass being thrown at Reed's SUV. Apparently, it was a cool idea, Mr. Brennan noted. He said Welcher's opinions are based on the study of evidence, and he goes on to the extent actually demonstrating those different assessments that he has made. Once again, the judge took it under advisement. This expert's going to get to testify, all right? He's got the credentials. And yes, there are people that their job is to go back and recreate things that break, under stress, and to see if you can recreate it. They're biomechanical engineers. That's what they do. And so he's coming in, and any problems that the defense has with it, they can cover on cross-examination. Anyway, they also heard argument on the government's motion to admit statements O'Keefe made to his friends and family about wanting to end his relationship with Miss Reed, as well as text messages he sent to her indicating the same. Some of those evidence were admitted at the first trial. They argued that we know from the statements that there was a tumultuous relationship, and he said that witness Jen McCabe testified at the first trial that when she gave Reed's direction to the Canton home to Miss Reed, that they were en route, Reed mentioned a mother of a child with whom Mr. O'Keefe had a prior relationship with was in the area. This is minutes before the alleged collision took place. Miss Reed's attorney, Alan Jackson, said Brennan had the timing wrong. My goodness, it's important to get some of the facts right. Mr. Jackson emphasized the words some. He said that conversation with Jen McCabe was the next morning after John O'Keefe had been found after he didn't come home. Prosecutors, Jackson said, have failed to show that Reed would have murdered O'Keefe as a result of learning he wanted to end the relationship. That is a hurdle over which the Commonwealth cannot leap for this admissibility for the evidence. Jackson said nothing Nothing. No witness testified that Reed and O'Keefe appeared lovey-dovey together at the bar before his death. Anyway, Brennan countered with quotes Reed gave to a journalist saying that when Jen was navigating John to the Canton house when I was driving, she said, it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Before accusing someone of getting it wrong, Mr. Brennan said, a person accusing should be right. Jackson said that conversation was solely between McCabe and O'Keefe. Anyway, they broke for recess, and they're coming back next week to get this done. Anyway, the judge says, we've got a lot of ground to cover. I suggest that we take the personal attacks completely out of this. Both sides, I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions and stop the ad hominem attacks. Following the lunch break, the motions hearings continued, including the government's attempt to bar the defense from advancing the so-called third-party culprit theory at trial. Who is that they're going to call to claim as a third-party culprit? Brennan said, what evidence do they have that they want to introduce? Reed's attorney, David Yannetti, said the defense has identified 3 potential third-party culprits present in Canton at the home at the time. Brian Albert, the now retired Boston cop who owned the residence, his nephew, Colin Albert, and ATF agent Brian Higgins, who the defense said had a romantic interest in Miss Reed. No one besides Reed has been charged in connection with Mr. O'Keefe's deaths. The judge said the defense must decide what to provide her to support a third-party culprit theory before she rules on that motion. At the first trial, she said Reed's lawyers couldn't open by alleging a third-party culprit, and Yannetti told jurors in his opening that Reed was framed for a murder she did not commit. Both sides also clashed about the defense motion to call a retired FBI agent who would testify to what he views as shortcomings and mistakes in the O'Keefe probe, basically an expert witness to talk about faulty investigation. Anyway, Mr. Brennan said allowing such testimony would invite the government to, in turn, call a state trooper to say the investigation was fantastic and the evidence is so overwhelming. This invites a debate between people's personal opinions, Mr. Brennan said. That's done outside of the courtroom, not in the courtroom. Jackson said that if prosecutors wanted to call a rebuttal witness to defend the police investigation, I have 2 words: do it. I love that. That's a classic battle of the experts. That's fine. The judge took the matter under advisement as well. They're coming back next Tuesday. Next, a woman kills her dog to make her flight. That's right. A woman in Florida is accused of intentionally killing her dog while inside the Orlando International Airport, allegedly drowning the animal inside a woman's bathroom because, well, she was not going to be able to take the dog on the flight with her. Allison Agatha Lawrence was taken into custody on Tuesday and charged with 1 count of felony aggravated animal abuse in connection with the incident. Now, on December 16th of 2024, officers responded to the airport after being notified about a dead animal that was found by an employee inside the Publix women restroom. Based on the investigation, the Orlando Police Department issued a warrant for the arrest of Miss Lawrence for aggravated animal cruelty in the 3rd degree. They believe that Miss Lawrence killed the dog inside the lady's bathroom by drowning it. Lawrence arrived at the airport with her dog, but did not have the proper paperwork that allowed her to take the animal on the flight. Lawrence was taken into custody in Clement, Florida, and she was released after posting a $5,000 bond. Next, this day in legal history, March 20th, 1854. The Republican Party is founded in Ripon, Wisconsin, with a platform opposing the expansion of slavery, impacting future legal frameworks like the 13th Amendment. On March 20th, 1899, Martha Place, convicted of murder of her stepdaughter, became the first woman to die in the electric chair. The execution was carried out on the New York's Auburn prison. On March 20th, 1906, the United States Supreme Court rules in Hale v. Henkel, affirming corporations' legal obligation to comply with subpoenas. On this date in 1942, the United States begins internment of Japanese Americans under the Executive Order 9066, a wartime legal measure later deemed in violation of civil rights. And on this date in 1956, the United States Supreme Court rules in Griffin v. Illinois, mandating states to provide trial transcripts to indigent defendants, advancing equal justice under the law. And on this date in 1987, the United States Supreme Court in McCleskey v. Kemp upholds the death penalty despite evidence of racial bias, obviously a pivotal capital punishment ruling. And then finally, our dumb criminal of the day. Aaron Jolonsky, upset that the karaoke machine at a Florida bar wasn't working. That's right. What's the logical thing to do? That's right. Point a Glock pistol at another patron and fire off a round. That's right. This apparently took place at the Overtime Sports Bar about 2:30 a.m. on Saturday, when the karaoke unavailability resulted in him exiting the bar upset about the music. Outside the Clearwater bar, the 26-year-old man tried to get Jolonsky to calm down. According to the affidavit, denied karaoke. Jolonsky was not in the calming down mood, according to the police. Anyway, he allegedly pulled a handgun from his waistband and pointed it at the victim, saying, "I don't effing care." Now, guess what? There were a bunch of witnesses that saw him fire a round off as well. Anyway, the victim says there are several photos of him performing karaoke, and he was in fear of Mr. Jolonsky. Thought he was going to kill him. Anyway, officers arrived at the bar. Jolonsky was still in possession of the Glock 9mm, which they say was illegal since, guess what? He was previously convicted of battery of a law enforcement officer, which means he's a felon in possession of a firearm. You're going to prison, Mr. Jolonsky, where you can karaoke all you want. Anyway, he's currently in jail, locked up on a $40,000 bond. Mr. Jolonsky, you are a dumb criminal of the day. Let it go, man. Let it go. And it's illegal to be drunk with a gun. It's illegal for a previous offender to be having a firearm and then pointing at somebody over karaoke. That's just dumb. All right. Thanks for watching. We'll see you next time on Crime Talk. Have a wonderful day. Remember, the Constitution matters.